vital provision in the Hindu Succession Act, that is a section 6 of the Hindu Succession Act. Now, I'll be sharing the slide. I'll start with the slide so that, and with the further discussion, I'll discuss the concept, I'll discuss the facts issue as usual, and wherever it is required that a particular concept is unclear, I would be giving you a clarification regarding it. So I'll be sharing the slide now. Please give me a yes if you can see the slides on the screen. Are the slides visible? Okay, great. Great. Thank you. Thank you so much. Now the case is Vineeta Sharma versus Rakesh Sharma. Right. So this particular case here is related to as I said, it is related to the section 6 of the Hindu Succession Act. Now, of course, merely saying section 6 of the Hindu Succession Act might not ring a bell. So what I'll do, I'll first of all start with a basic concept or the basic concepts related to your case. Then I'll discuss the provision, which is the vital area which has been discussed in the case. Then I will start and proceed with the facts, issues, discussion, arguments, and everything. Now, essential concepts related to the case. Now, there are these three concepts has been repeated in the case. These three concepts, this has been repeatedly used in the very judgment again and again. Therefore, first of all, I'll be discussing these three concepts. The first concept is what is a co-partitionary and what is a joint family. Now, the old Hindu law, which basically consisted of two schools of law, that is your Mitaksha school of law and your Dayabhaga school of law. Now, after the Hindu Succession Act, we have a common Hindu devolution of property, that which is according to your Hindu Succession Act 1956. But still, we have the remnants of the Mitaksha school of law and the Dayabhaga school of law through the term co-partitionary property and joint family property. Now, what is a co-partitionary? This is a co-partitionary. Now, I have used the term son, grandson, and great-grandson, and not daughter, granddaughter, and great-granddaughter, because this is what is the original position of a co-partitionary system. So, including the ancestor, there has to be 3 generations. So, this makes a co-partitionary. So, there has to be 4 generations, which makes a co-partitionary. Now, this very position was altered by the amendment in the Hindu Succession Act in 2005. After the amendment in 2005, this was the term daughter was added to the co-partitionary system. Now, the co-partitionary system is a part of the joint family. Now, when you define joint family, it basically means the ancestor and all the lineal male descendants, right? But the co-partitionary system segregates only the lineal male descendants, whereas joint family system might also include, and also does include, the female relatives, the widowed, the daughter, the unmarried daughter, the wives, the children, and everyone. But co-partitionary system is just a part of the joint family system. Then the next concept here is devolution of property, number 1, by survivorship, number 2, by succession. Now, devolution of property by survivorship, it means that in the co-partitionary system, I'll again refer back to this diagram over here. The moment the grandson dies and there is a great-grandson, or for example, the ancestor has 3 sons here, right? And each of these sons has a child. The moment one son dies, the property will not go to his child. Rather, his share of the property will go to the other co-partitionaries or his brothers, and not to his child. So this is your right by survivorship. So whoever is a co-partner, the property will go to him and not to the descendant of the deceased. So this is your right by survivorship. Whereas right by succession says that the moment the particular co-partner dies, the property will go to his descendant and not to the other co-partners. So whoever survives the um, intestate, the person whose property is in question, he will get the property, and it will only go to that particular branch and not the next branch or the next generation. Third concept here is with respect to a term called notional partition. Now, the literal definition of the term partition is very clear to all of us. But what is this notional partition? So, to understand this term called notional partition, it is very much required that we go to section 6 of the Hindu Succession Act. Now, I have not provided the full section, amended section, but only the essential part which is relevant to our judgment. Now, as I said, that the amended section 6 provides that the daughter can also be a co-partner. The daughter can also be a co-partner, right? So by birth, a daughter could be a co-partner in the same manner that of a son. So I am highlighting this particular word here because it says that the right of co-partnery or the right to get the property of the ancestor is not something which is given to you by someone. Rather, it is a right which is enshrined by birth. So the daughter will also have a right by birth. I would ask you to remember this particular term because this is the particular term or phrase on the basis of which the whole judgment has been decided. The daughter will have same rights in the co-partnership property as she would have if she had been a son. So exact same rights that of a son. Not only this, the daughter will also have the same liabilities. The daughter will also have the same liabilities that of a son. So she will have the same right. She will also have the same liabilities. So if the father has left back any debt, it is not only the son who is going to dispose of the debt or satisfy the debt, but the daughter is equally liable for the same. Now, there is a proviso here. The role of proviso is to carve out an exception or to put a red light to make you wait and focus on the particular part. It says that provided that nothing contained in the subsection shall invalidate any disposition or alienation, including any partition or testamentary disposition of property which takes place before 20th day of December 2004. Now, here let's read the introductory line to section 6. The introductory line to section 6 talks about the application of the Hindu Succession Amendment Act 2005. Right. So it says that on and from the commencement of the Amendment Act, this particular amendment will be applicable. So what will happen to all this devolution of property which might have taken or which is in question before the particular date? So that is what the proviso clarifies about. It says if any disposition means any transfer of property, or if any alienation or any giving away of property has been made before the cutoff date, this is the cutoff date, 20th day of December 2004. So before the cutoff date, if any particular property has been disposed or alienated or it has been given away by virtue of partition or testamentary disposition, you cannot challenge it. Right? So it has to be a final disposition. It should not be something which is preliminary or pending or it is sub judice. Right? It has to be a crystallized right which has been given to any particular person. So the daughter cannot reopen it. So this is very much essential here. So after this particular part, I'll take you to this particular explanation here, which is under subsection 3. Subsection 3 is where we talk about notional partition. The notional partition says that what if the intestate or the particular person in question whose property we are talking about, he has died and there has been no partition. So how are we going to segregate the property between the co-partners or the existing descendants? So there, the law provides a term called statutory partition, or something, as we already we know about it. The term we repeatedly use, something which has not actually happened, but we presume it to be so. So we presume that a partition has occurred before the death of the intestate or before the death of the person in question whose property we are discussing about. So it says that For the purpose of this section, the interest of the Hindu Mitakshara co-partner shall be deemed to be the share in the property that would have been allotted to him if the partition of the property had taken place immediately before the death. So we are getting a presumption here. The partition has not actually happened. We are presuming that the partition has happened, and on the basis of that, we are going to segregate the property and pass it on to the existing co-partners or the descendants. So this is notional partition. This has not happened actually, but we presume it so that there will be an easy distribution of property among the descendants. So that is a notional partition. Or the other terms for it is statutory partition, partition which is presumed, and so these are the three terms which could be interchangeably used. Now, finally, there is again a last exception to this section which says that the term partition, if a property has been partitioned, right? If a property has been partitioned before 20th day of December 2004, this is the cutoff date. Again, I'm reminding you, any partition which has occurred before it, then for the purpose of it, the partition cannot be reopened again. The daughter cannot ask for reopening of the partition and claim a property share in it. The term partition has been defined in the explanation, which says that it should be done by a deed of partition or any deed, a deed of partition registered under the Registration Act or any partition by the decree of the court. Right. So this is your section 6. Now, giving you a basic idea about the concepts involved in the section in question, we move on to the case now. We start with the case. So the facts of the case are, so Mrs. Vineeta Sharma, she's the daughter. She has 3 brothers.
Sorry to interrupt.
Yes.
Can you explain the notional partition once again?
Sure.
Thank you, ma'am. Thank you.
Achha. For example, I'm giving an illustration to explain you. A is the particular person or the Hindu Mitaksha co-partner whose property is in question to be divided among the children. For example, he has 3 children. The Mitaksha co-partner A dies, right? Now, the moment he dies, he has not left a will. He has not left a will. And he has died, he has passed away after the Amendment Act. After the Amendment Act. Now, property to be divided among the children has to be partitioned first of all. Why it is required to be partitioned? So that you can understand which particular person will get how much amount. Now, since we are at a very preliminary stages under section 6, section 7, 8 and onwards, it says that in the line of the children, each child will take one share. So how are you going to determine that share, that equitable share, that equal share? That equal share can only be decided when there is a partition by meets or bound or physical partition. So now the person has died. The property belongs to the Hindu Mitakshara co-partner. It has to be partitioned with his consent, but he has already passed away. So here, there is a provision which has been made by section 6 of the Hindu Succession Act that you are going to presume that there is a partition which has occurred before the death of the Hindu Mitakshara co-partner. You're going to presume it. It's not an actual partition. It's not an actual partition. It is not a partition by meets or bounds, but you're presuming that the partition has happened so that you can segregate the amount only for the purpose of determining the share of the co-partners or the share of the widow or the share of the anyone who is supposed to get the part of the property. Only to determine their share, you are presuming that there is a partition which has already occurred. But actually, in the eyes of law, it is not an actual partition, or it will not have the full effects of partition which we study under the civil procedure. It is only a notional partition for the purpose of determining the shares of the people who are supposed to get a share. Right? Is it clear? Okay, thank you. So we move on to the next part here, the facts of the case. So Mrs. Sharma here is the appellant. The case is against, and the respondent is Mr. Rakesh Sharma, Satyendra Sharma, brothers of Mrs. Vineeta Sharma, father Mr. Devdas Sharma. Devdas Sharma has already passed away on December 11, 1999. So he has passed away before the Amendment Act, the 2005 amendment. And there's a third son or third brother of Mrs. Vineeta Sharma, um, but he has also expired. So the father has in total four children. So each particular person is supposed to get 1/4 of the share if we take into consideration that the Amendment Act applies to them. But there is a point of conflict. What is the point of conflict here? The point of conflict here is that, if you remember, I'm repeatedly using a term that we have a cutoff date for Section 6. The cutoff date is 20th day of December 2004. The Mitakshara co-partner or the property in question which is supposed to be divided, it should fall after the date, or the particular person should die after the particular cutoff date. But here, Shri Devdutt Sharma, he has passed away before the cutoff date. So now the question is whether Mrs. Vineeta Sharma is supposed to get a share in his father's property. Now here, the law is silent. The law is silent. Therefore, this is a point of conflict. Now, we have a few precedent. The very reason of the conflict is the precedents actually. I'll first of all tell you the issue of the case, then we'll go to the precedent. The issue of the case is whether the amended Section 6 of the Hindu Succession Act 1956 should have a retrospective application. Whether it should have a retrospective application. Now, here is a food for thought for all of you. I'll give you two terms: prospective application and retrospective application. Now, while going through the judgment, there is one point where I'm going to discuss both of these terms. In addition to that, I'm going to introduce a third concept, a concept called retroactive application. So you have prospective application, retrospective application, and retroactive application. I will ask you to all to ponder over these three concepts, and when I come to the particular point of discussion, I'm going to take your point of view or ask you what do you mean by these three terms. So whether the term section or whether Section 6, the amended Section 6, will have an application to Mrs. Vineeta Sharma. Now this is one issue of the case. I have divided it into two sub-issues, because even if it is just one issue, when you go through the actual judgment, you will find that there are many issues. There are many issues, sub-issues, which has stemmed out of the particular issue in the case. Primarily, I have put all the sub-issues under two categories. First is, what is the nature of a co-partnership right? What is the nature of it? Is it a birthright? Is it given by law? Is it given by the family? Or is it optional? Is it mandatory? Is it directory? Does partition bring an end to a co-partnership? Now, in the current case, the brothers have already divided the property among themselves, right? Or at least there is a preliminary decree at least to divide the property among themselves. So whether the partition brings the end to the co-partnership. So these are the sub-issues which I found in the judgment. So I prefer to put it down in front of you. These are the two cases, or the two precedents rather, which is because of these two precedents, we have the point of confusion. One is Prakash and others versus Phulvati. Second is Dhanamma and versus Amar. In Prakash versus Phulvati, the ratio of the case is Section 6 is not retrospective in application. Section 6 will only be applied to the living daughter of a living co-partner. So it says that on the date of the commencement of the Amendment Act, both the father and the daughter should be alive. If on the commencement, either of them is dead, Section 6 will not be applied. So this is the standing position of Prakash versus Phulvati. The Prakash versus Phulvati is actually the precedent. Then we had the case of Dhanamma versus Amar, where it says that daughters will get full rights of Section 6, but again, it did not provide any clarification whether it is retrospective. So, interpreting the case, the current position is that it has a prospective application, but it does say that the daughters have full rights with respect to the property. Since Dhanamma's case is unclear whether it is retrospective or not, we come to the current case. The current case, along with the fact that it is a civil appeal, it is also a result of many special petitions where also the government has also the union has also played a very essential role in arguing for the rights of the daughters. Now we'll discuss the case under the following headings. We'll discuss the case under the following headings. We'll discuss it under the submission by Union of India, even if Union of India is not a party here, but still the Union of India has a very significant contribution to the current case, um, which has provided for keeping in point of view the constitution and other equitable principles of justice and good conscience. Then we have the submission from the amicus curiae, submission from the respondent, and find the submission from the appellant, and finally we go to the ratio of the case. The ratio of the case is essential, but we'll also see, or we'll also go through the submissions by the various parties. Now, can anybody tell me, even if the Union of India is not a party here, why can the Union of India make a submission here? Has anybody any idea? Even if you go to the judgment, Union of India is not a party. Why does, even if the Union of India is not a party, the Union of India can make a submission? Does anybody have any idea?
जब मैम कोई क्वेश्चन ऑफ लॉ में कॉन्फ्लिक्ट होता है तो कोर्ट क्वेश्चन ऑफ लॉ की क्लियरिफिकेशन के लिए यूनियन ऑफ इंडिया से, क्योंकि क्वेश्चन ऑफ लॉ का मतलब होता है कि किसी भी चीज पर इश्यू क्लियर नहीं है, तो वो गवर्नमेंट के प्रोस्पेक्टिव को जानने के लिए उनको नोटिस भेजते हैं कि आपका क्या कहना है इसमें, तब गवर्नमेंट ऑफ इंडिया किसी भी केस में आके अपने सबमिशंस कोर्ट को सबमिट करती है, वेदर इन फॉर्म ऑफ एसजीआई और एजीआई.
Correct.
Ma'am, because this was 2005's amendment, which was brought by the parliament, and this two cases, which is Dhanamma's case and the another one case, is of two judges bench, and hence they were contradicting each other. So for getting the clarification from the Union of India regarding the effect of the date, the three bench judges in this court sought the opinion of the government of India.
Okay.
Because already two judgments were contradicting each other.
Great. Thank you. Anyone else? Anybody else who could previous both judgment and two they contradicted? One more angle to it is that, especially in cases like this where there is a public interest involved, and also the fact that the positions is contradictory. As Anuj mentioned, and also Arpit mentioned, and also Sashwat mentioned, that here in such a case where a public interest of such a severe nature is involved, the government could be asked of its opinion. Correct. Thank you so much. Now we'll come to the submissions first of all by the Union of India. The Union of India, as I said, that it coined a new term, not coined a new term, rather it introduced a new term into the applicability of the timeline of applicability of the law. First of all, the first argument is that the Amendment Act is not retrospective but retroactive in operation. The Amendment Act is not retrospective but retroactive in operation, since it enables the daughters to exercise their co-partitionary rights on the commencement of the Amendment Act, because a co-partitionary right is a birthright. Now, there's a difference between retrospective application and retroactive application. Retrospective application, as we all know, that the law has a backward application on a particular set of event. Even if the event has occurred in the past, the law will still apply in a retrospective form, in a retrospective way, or a backward application. Retroactive means that the application will be prospective. The application will of course be prospective, but the application will be on the basis of the facts which has already happened. And what is the fact which has already happened here, which is in past? That is your right of a daughter to the property, or the right of co-partitionary, or the daughter's right of co-partition of the property, is something which she gained the moment she was born. So the moment you are born, the moment a daughter is born, a Hindu daughter is born, she gets a birthright in the property, in the co-partition property. So that particular fact, that particular situation is the circumstance. And on the basis of that circumstance, she gets a prospective right on the property after the 2005 Act on the co-partitionary property. So even if the application of the law is prospective, but it is based on certain antecedent which has already happened. The antecedent here is the right of the daughter on the property which she gains by birth. Right. So this is one clarification. Again, I'm going to repeat it when I come to the ratio, we discuss the ratio. The amendment will not affect the rights which has been crystallized through the partition. Of course, anything which has been opened, decided, and shut down, everything has been given to the respective parties. You cannot open it again because it will open a Pandora's box. So any right which has been crystallized through a partition, the partition can be a partition, if by section 6 we discussed, a partition could be by a registered deed, or a partition could be by a decree of the court, but it will not include a preliminary decree. I'll clarify it here. It should be a decree which has been given effect, the partition has been done by metes and bounds. Only then the amendment will not open the part or reopen the partition again. This is a catch which has been clarified by the Union of India. The unamended section 6 provided limited share to women relative. Now, when you read section 6, the 1956 section 6, you will find that there is no mention about why daughters are not being co-partners. Rather, it provided a limited share to the women relative, especially to the women relatives in the Schedule 1 of the Hindu Succession Act. Right. Now, that particular provision was itself, according to the Union of India, very much discriminatory on the basis of gender. Of course, straight away on the face of it, it challenges Article 40. The amendment shall not affect or invalidate or any disposition or alienation, including any partition. So if any property has been disposed of by the ancestor or by the Hindu Mitaksha co-partner, or after partition it has been disposed, or it has been given away in a testamentary disposition or through the will, before this cutoff date, the amendment will not affect it. The amendment cannot, or the daughter by virtue of, just a second. So the daughter cannot reopen it if the alienation disposition of the property has taken place before 2012. So if, first of all, the partition has taken place before the cutoff date, the daughter cannot reopen it, the rights are crystallized. If the property has been disposed of before the date, the daughter cannot reopen or cannot go back to the buyer of the property and ask for a partition. That why was my consent not taken? So these two things has been expressly taken away from the purview of the amended act, amended provision. The death of the Hindu co-partner, father or any other co-partner is only relevant for the succession of the co-partner property. Right. Now, this is one thing which is important here in the sense that a very important characteristics of the co-partner system is that, first of all, you get a property or you get a right by birth. Now, if you remember that a concept I was starting with, that is a right by survivorship. A very essential characteristic of right by survivorship is that you have a unity of possession and community of interest over the property. Unless and until there is no partition, you cannot say that this property is mine, or this part of the property is mine, this part of the property is mine, because there is a unity of possession. The shares in the property, they will fluctuate. The moment a new a member is born, your share will decline. The moment any person dies, your share will increase. So the interest in the property is always fluctuating, and you cannot put a point that this particular part of the house is mine. You do know that 1/4 of the property is yours, but you don't know which 1/4 is yours, right? You can only find it when there is a partition. And that partition can only take place when the particular ancestor, he dies and the partition opens, or he has, before his death, he can open the partition and segregate the property. But what if he has passed away and the partition has not occurred? So in such a case, his death will start with the very mechanism of partition, because each member wants his or her share of the property. So this particular part of the submission says that you cannot consider that the death brings an end to the co-partnership. Rather, the death starts another chain of the co-partnership. How? Now, I'll again take you back to this diagram over here. We have ancestor, we have son, we have grandson and great-grandson. Now, this particular person here dies. That does not mean that the co-partnership is dissolved now. The moment he dies, one more person gets added here. That is the great-great-grandson. and one more cycle of co-partitionary starts, right? So you cannot say that co-partitionary or the death of the ancestor brings an end to the co-partitionary. Rather, the co-partitionary continues. So therefore you cannot say that the moment the father dies, the daughter, she could have claimed when the father was alive because she was part of the co-partitionary. The moment the father dies, the co-partitionary ends. No, co-partitionary can never end if you see the cycle of generations. The moment one particular person dies in the chain, the next particular person takes the place. So co-partitionary system never comes to an end. On the co-partitionary's death, the notional partition is drawn only to determine the co-partitionary's interest and nothing else. Unless and until you do not mention your animus to get a partition from the joint family, you would still continue to be the part of the co-partitionary. So it is not division of property or division of the kitchen, division of the temple, division of the kitchen utensils that provides a division in the joint family. No, the animus has to be provided. So a mere death of one co-partitioner will not divide the whole property, or the co-partitionary system will not come to an end. The requirement of registered partition deed is directly not mandatory, because even an oral partition is allowed. If by oral partition the ancestor has divided the property and he has people to substantiate that there was an oral partition, it can be proved. So such oral partition, which can be substantiated by documents or any evidence or any witness, can also fall within the exception of section 6. Every son by birth became a co-partitioner, and because of birth, the son became entitled to be a co-partitioner. So this particular paragraph here, the Union of India or the Council has tried to explain the concept or the jurisprudence behind the co-partitionary property. So it says that by birth you get a right and you become a co-partitioner. You are entitled to claim a share because you were born as a son or as a member in the co-partitionary system. The rights of the co-partitioner should be enlarged, keeping in consonance with the constitution. Now here the council has summed up everything by saying that this reference has been made again by the judge, so by the court, where it says that the Hindu system, the Hindu culture, or the Hindu system of property or marriage, it's ever enlarging. It has never anywhere restricted itself. So it keeps on growing every day. So if you see the Hindu jurisprudence, the rights of the co-partitioner, it has enlarged, right? So keeping in consonance of the constitution, the Hindu jurisprudence will also have to be in consonance with the norms of the constitution. So even if it is a son who has by birth become a co-partitioner, it is very much essential that we enlarge that concept, right? And keeping in consonance, we have to also add the right of the daughter to it. Now, it's a very common question to be asked. I presume everybody will know about it. Can you tell me why is it especially limited to the son? What is the reason behind it? Why the co-partitionary system only consists of male lineal descendants? What is the reason behind it? Anyone?
Ma'am, because in earlier times, women would they were not granted any rights. So we are still living in a patriarchal society. So all the rights were given to the son only, and there were no rights granted to the
extensions of
woman.
generations.
Extensions of what?
Generations.
Generation. There is a very common reason.
Vansh aage badhna, that extension of generations.
Vansh. Anyone? Your voice is breaking, Chandralekha. Your voice is breaking.
Am I audible, ma'am?
Yes, your voice was breaking. Yes, please repeat.
Yes, ma'am. Actually, I was saying that earlier times there used to be the concept of performing the puja of Pinda.
Pindadan. It's not earlier. Even now also we have the same.
The Pindas that would be performed only by the sons.
Correct.
So it's
great. Good. Yes. So the very concept of Pindadan is why we have only male lineal descendants in the co-partitionary system. It's correct. It's about also carrying forward the lineage. That's also correct. But primarily it rests on the concept that whoever can provide the Pindadan so that the ancestor, they can be set free of any debt after the death, right? So because it is the son who has been granted the right to provide Pindadan, therefore the son gets the right as a part of a co-partial system. Because the daughters, they're not allowed to provide Pindadan, they were expressly removed from the system co-partially. Now, that is what was challenged by Union of India here. That you cannot restrict that definition, you cannot bind yourself within such a norm, because as society progress, we have also examples where daughters are also providing Pindadan or also are giving Mukhagni to their parents. So we are not in that society still where the son will be expressly discharging the function. So you have to also keep in consonance with the constitution. So this is one illustration which I wanted to clarify here. Next, coming from also the amicus curiae has been appointed by the court, because, as I said, this particular case is not with respect to Vineeta Sharma or Rakesh Sharma, but the case in front of the current court is also a result of 7 to 8 SLPs. So the amicus curiae has also been appointed in the court to give you to provide his side of the to provide a very neutral provision for argument for the current case. Now you will find that the arguments which is
one doubt. I have one
Yes.
doubt. Like this principle of Pindadan or Mukhagni cannot be restricted to essential religious practices of Hindus. Like
essentials. If you see, anywhere. Sorry, if I may give you an example. For an essential religious practice, for a religious practice to be an essential religious practice, can you tell me, I think you all have completed the Sabarimala judgment. Can you tell me what are the grounds for a religious practice to be an essential religious practice? When can you call a religious practice to be an essential religious practice?
मैम जो लंबे टाइम से चलते हैं
When it is followed continuously
Good.
for a long period of
for a
time.
long period of time.
Then that's also a custom. Can I call a custom as a religious practice? Because you are giving me a definition of the custom. Should it have any religious backing by religious scripture? Can you tell me why talaq, the triple talaq, it was struck down as not being an essential religious practice? The court did consider that triple talaq is not an essential religious practice because, first of all, it does not have any backing from the Holy Quran. Second of all, in the very orthodox Islamic countries, we do not find the provision of triple talaq, right? So it is not only the continuity in the practice, but it should also have a strict religious backing. So, sir, the person who asked me the question, do we have what the Mukhagni and the Pindadan, do you have any religious backing for the particular provision or the particular practice? Have we seen it anywhere? Good, Sashwata, thank you. Anyone? You can say that at most.
The essential religious practices can only be told by that those person having excellent command knowledge of the religious. Like I doubt with somewhere it was discussed in court in Ismail Faruqi's case that court cannot decide what is essential religious practices or what is not.
Right.
Ma'am, my question is that court can decide what is essential religious practices.
Yes, of course the court can
what
decide. Yes, right. The court has the sole power to decide. Because anyway, who is again a very important person to decide whether it is an essential religious practice is again, everybody will claim that we are important in the religion to discuss about it. So yes, you are correct. The court has the power to decide whether it is an essential religious practice or not.
But when court can decide this, whether this practice is essential or not on the basis of some terms, because court has so many times declare some principles. On basis of those principles, they test every religion, that every principles, whether it is essential or not. Like in Sabarimala, court further elaborate if any practice is essential, it must be relate some nexus between the
Correct.
things.
Yes. Nexus between, this is what I was asking. Yes.
Nexus between the object of the act.
Yes. Right. So since in the current case, the very yes, anybody is asking anything? In the current case, the court has not gone actually in the very case of Vineeta Sharma versus Rakesh Sharma as to whether Pindadan, or it is not discussed here actually, or I have not come across any such discussion where Pindadan has been considered as an essential practice. But if we consider the very reason given in Sabrimala case, we can take the help of that very ratio to help us to understand whether Pindadan is an essential practice or not. Or it is not only Pindadan, rather Pindadan by a son only, right? So that is the question. It is not Pindadan is an essential practice or not. Of course, it is an essential practice. But whether Pindadan by the son exclusively is an essential practice or not, that is what is to be decided. Right. Okay. Moving forward, the Parliament Section 6 subsection 1 clause declares that a daughter to be co-passionate is a co-passionate by birth. Again, the amicus curiae is repeating whatever the Union of India said, because it is very on the face of it. Now, if you remember, when I just started with the section, the very first line of the subsection says that by birth, the term by birth. So co-passionate right is something which is given to the daughter by birth. So if you are giving a right to me, if you are giving the particular right to me by birth, where does the question of prospectivity, retrospective application arise? Anyway, I'll get the property, right? Because the right has been given to me by birth. And a right without an enforcement is not possible. Who is the amicus curiae? I'll get back to who's amicus curiae in this. I'll get back to after this discussion. Now, the Parliament. So here, the question of retrospective or the retrospectivity or the prospectivity will not arise, because the co-passionate or the daughter, the daughter's right to be co-passionate is a right by birth. The Parliament's Standing Committee report. So what the amicus curiae has also referred here to the Parliamentary Standing Committee, which was, this case, before this case or before the SLPs or before, throughout the history, whenever the question of Section 6 comes into question, every time a set of group, they fight or they there is agitation with respect to, including daughter within the co-passionship. So the Parliament established a standing committee to, to at least to give a correct viewpoint as to whether it is feasible enough to put or to add the category of daughters within Section 6. So the Parliamentary Standing Committee, it indicated that the benefit should be given to the daughters, but the benefit should be given after the amendment, right? But this has to be read with the first argument, that is, the right is a birthright, and it has to, even if it has been given application after the amending legislation or after the amendment, but it has still to be given. There is no question of prospectivity or retrospectivity here. If the co-passionary was disrupted by the act of the parties, if the co-passionary was disrupted by the act of the parties or by the death of the parties in partitioner's sale, the daughter could not get the status of the co-passionary in the co-passionary. The status conferred cannot affect the past transactions of alienation, disposition, partition. So this is what we have already, again, this very same thing to discuss, or same thing which has been repeated again by the amicus curiae, that if something has been already set aside or something has been expressly decided or something has been discussed and set aside or the rights has been granted, right, you cannot reopen that. So again, the very same thing has been repeated here. The daughters conferred with the status of co-passioner under the Amendment Act cannot challenge the past transactions. Past transactions, the disposition, the alienations and everything which has already taken place, the daughters could not challenge it again. The daughters should be alive as on the date of the amendment. Here, the amicus curiae has tried to take a slightly different position from that of the, Union of India. The amicus curiae has said that The daughter could not challenge the past transaction, but at least the daughter should be alive. Keep aside the father, keep aside the ancestor who is in question, but at least the daughter should be alive on the date of the 20th December 2004. Now, there should be living co-partner to whom the daughter can inherit to become a co-partner, right? So this, the amicus curiae slightly deviated from the position of the Union of India by reiterating what was provided in the in Prakash versus Fulvati's case. Now, you might find a bit of confusion here when you read the arguments of the amicus curiae. But remember one thing, that this is the conflict which has been resolved by the court at the very end, when it has tried to define the term co-partiality. So I am very much sure that you people will, with this paragraph, you'll find that confusion again re-emerging after reading what the Union of India said. But I'll assure you that it has been set to to finality by the court when we come to the issue of the case. Submission from the respondent, right, Mr. Rakesh Sharma. Of course, since the respondent will actually go against whatever whatever Miss Vineeta Sharma will claim, the respondent has used Prakash versus Fulvati here. So they adopt the interpretation of Prakash versus Fulvati, where it says that the living co-partner of the living ancestor should get a property, has been reiterated by the respondent in its argument. One more thing which the particular person has, the respondent has tried to raise, is that it has again tried to keep a deviation, or distinguish between a married daughter and unmarried daughter, right? Now, what happens generally? You listen. Now, it is not always the married daughter who comes to claim the share in the property after the father has died. It is generally the son of the daughter, or the husband, or somebody who is related to the married daughter, or the married daughter does it at the behest of somebody. So what it does, everything when it has been set aside, or the daughter who was already married and gone to her family, she comes back and reopens a partition, or she tries to reopen the division of the property. So what will happen? It will actually disturb everything. So that is what the respondent wants to clarify here. That has not been clarified. This has not been clarified in the particular case of Vineeta Sharma versus Rakesh Sharma. But when you go to Prakash versus Fulvati, you will find this discussion. It is the problem arises when the married daughter and the relatives of the married daughter, that is the son or the children, the great grandson, they come and they start claiming right in the property of the daughter, or who has the particular claim in the co-partial property. That is where the problem arises.
Claim to the daughter only, na? Like if the child of the daughters comes and they claim, but they will claim to the daughters only, na?
And
yes, it is immaterial that whether the daughter is married or not. If she is co-partner by birth, then she is having her right.
Sorry,
ma'am, if a daughter is a co-partner by birth, then it is immaterial that she is married or unmarried.
Correct.
She has the right.
Correct.
Ma'am, then why the issue of married daughters?
Exactly what you have said was provided by the court when the court talked about this distinction, this false distinction created by the respondent, right? Okay. Now listen why this argument was provided, why married daughters were separated. Because this is what I was saying, that it is not the daughter, the married daughter, who comes to claim the property. Rather, it is the children or the great-grandchildren who will come and reopen the everything. They'll come and claim in the property of their grandfather, right? So now, for example, the property has already been divided. The son, the brothers of the daughter, the brothers of this particular co-partnership, they have taken the property. The great-grandson comes and tries to reopen everything, that you have not given my mother or grandmother her right in the property. So I'll be reopening everything and taking my share. So what happens? It opens a Pandora's box, right? Everything will be starting again. And a civil case, you must know that it is not a small thing, right? First of all, it takes a long time to get settled, hard labor to get settled. So again, when everything is settled and you're reopening everything, what happens is that again everything is disturbed. What if the particular share of the property has been sold to somebody? So it opens a chain of litigation. And always remember that the primary aim of the court, or the primary aim of the judiciary or the legislature, is to lessen litigation, right? So that can be reason that, the very argument you're taking, it was set to finality by the court, saying that there's no distinction. The right is by birth. There's no distinction between a married daughter and unmarried daughter. But why this ground was claimed or raised in Prakash versus Kulvati was to lessen such litigations. That if you are giving that right to the married daughter, then the children, the great grandchildren will come and reopen every set of partition, and it will give rise to a set of litigations which might hamper everything. So that is the reason why this distinction was created. Otherwise, except this, there is no reason. Did you get it, Arpit?
Yes, ma'am. Thank you, ma'am.
Next, preliminary decree closes any window for claiming share. Respondent says that, here the respondent again, he has raised a new ground that he says that not only a final decision or a decree, but also a preliminary decree also creates, closes every window for claiming a share. So now remember that if a litigation is pending, and during the pendency of the litigation, an amendment act has been passed, right? So whether the amendment act will have an application on the pending litigation. Generally, what we have read, or what if you people must have gone through also, if there's a pending litigation, the law will be applicable. That is what happens in a civil law, right? Respondent says that a preliminary decree is also a decree, right? So when you see the provision, the civil procedure, the civil trial, preliminary decree establishes the right, but the final decree, it will segregate the rights physically. So preliminary decree will say that each particular party will get 1/4 of the share, 1/4 of the property. The final decree will physically divide it, or will execute the preliminary decree. So from that point of view, the respondent says that even a preliminary decree is also a decree. That is also conclusively defining the rights of the parties. So in such a case, even a preliminary decree will shut the window for the daughter from claiming any share in the property. The daughter of a co-partner means daughter of a living co-partner. Daughter of a co-partner means daughter of a living co-partner. Reiterating Prakash versus Fulvati again. That daughter of a co-partner means living daughter of a living co-partner. But everyone, when we studied section 6, did we see the term living anywhere in section 6? This particular ground here will be used by the court to give finality. We are going to use a very simple tool of, or the court uses a very simple tool of interpretation, that is literal rule of interpretation. That we cannot read anything into a provision which is not provided in the provision. If the provision is very clear on the face of it, you cannot read words into it. I'm putting it here so that when we go to the ratio, it will be more easier for you to understand. I'm contrasting and trying to clarify it side by side. The explanation to section 6 subsection 5 cannot be interpreted to take away the rights crystallized upon the surviving co-partners of the joint family under the statutory partition. What is the other name of statutory partition? What is the other name of statutory partition?
Notional partition.
Great, thank you. So again, this particular condition you will find repeatedly. Every second page, every alternate page will have the reiteration of this right here, this particular point. That if anything which has been crystallized, any disposition made, any alienation made before the amendment, it cannot be reopened. This thing gets repeated. So again, the respondent has used the same argument. This has been used by the amicus curiae. The amicus curiae, this has also been used by the Union of India. Finally, the submission from the appellant. The appellant, again, as I said, that a very simple tool of interpretation has been used by the court and also the appellant. The appellant here says that you cannot read words into statute. The literal tool or the literal rule of interpretation has been used to explain that if a particular provision, if you go into the literal meaning, or literal meaning means that the general meaning, the simple meaning, the dictionary meaning of the term, in addition to the context of the law, if you're satisfied, if it provides you everything what is needed, you cannot read words into it. That is a literal rule of interpretation. Now, if you read section 6 along with the statement of objects and reason, that the statement and if you go through the statement of object and reason of section 6, the amended section 6, you will find that the legislature, the intention of the legislature has been clarified, saying that when you are excluding the daughters out of the purview of section 6, if you're excluding, it is challenging or it is hampering the principle of equality or right of equality under the constitution. So this is what is in gist, what is the statement of object and reason provides. So reading the literal meaning of the provision along with the statement of object and reason, it provides that nowhere the word living could be added, because it deviates from the literal meaning as well as it deviates from the statement of objects and reasons. Right? So we cannot read it. This adding, if you're reading words like living co-partner of a living daughter, living daughter of a living co-partner, you're actually adding to the text of the provision of section 6, which is actually violating the authority of the legislature. So you cannot do it. Referring to the definition of co-partner in the case of Satyaprema Manjunath Gowda versus Control of Estate Duty Karnataka, the right of a co-partner is a right by birth. Right? Right of a co-partner is a right by birth. So in this Damodaran case, in this case, the court, why has this judgment has been referred by the appellant? The appellant has tried on, if you refer to the paragraph where this particular case has been cited, you will find that through this case, the appellant has tried to establish the meaning of co-partner. So if you remember at the very first or second slide, when I said that there are few sub-issues which I'm taking and putting in front of you, one of the sub-issue was the nature of the right of the co-partner. So it is a right by birth, and it is only when it is established or that the property has been divided physically. Partition by bits and bounds means physical partition. So the person who, generally the court appoints a particular person who goes to the property, who will measure everything in the property, divide it, and give right the particular share of the property to the particular co-partner. So everything, when it is divided by physical, by bits and bounds, the partition is final. So if a partition is already done by bits and bounds, then the partition could not be reopened. But if it is a preliminary decree, where only it has been said that these shares has been mentioned, it will not fall under the partition, or it will not fall under the final partition. The partition has to be by bits and bounds. This is what the appellant tries to say. Yes.
मैम, यहाँ पर आप जो कहना चाह रहे हो, इस पर्टिकुलर केस में ये बोला गया था कि अगर पार्टीशन एज पर द एक्ट हुआ है, मतलब उसमें डॉटर्स को भी हिस्सा दिया गया, तो ओके, अगर नहीं दिया गया तो उसको वापस से रीओपन किया जाना चाहिए.
I cannot get you. Can you just repeat once again?
मैम, क्या इस केस में ये हुआ था कि, मतलब क्या आप ये कहना चाहती हैं कि जो पार्टीशन एक बार हो गया, बिकॉज एक्ट जो मतलब एक्ट इनफोर्स होने से पहले जो पार्टीशन हो गया, उसमें अगर डॉटर को राइट नहीं दिया गया, तो क्या उस केस में भी वापस से पार्टीशन को रीओपन किया जाएगा, डॉटर्स को उनका राइट दिया जाएगा थ्रू पार्टीशन?
देखो, यहाँ पे दो चीज है, ठीक है. एक है पार्टीशन जो कि बस ओरली हुआ है, ठीक है, बट वो पार्टीशन एक्चुअल डिविजन ऑफ प्रॉपर्टी नहीं हुआ है. एक्चुअल डिविजन मतलब फिजिकली एकदम एक कोई गया है, पूरा डिवाइड किया है प्रॉपर्टी को, सबको अपना अपना शेयर एकदम लिख के आया है. दैट इज पार्टीशन बाय मिड्स एंड बाउंड्स. Unless and until that thing has happened, you cannot say that it is a partition. If I'll just go back to section 6, wait. Okay, I'll just ये देखो, ठीक है. Partition means if अगर partition ये दो मोड से हुआ है, उस केस में the daughter cannot reopen. First of all, if the partition has been executed by a deed of partition, registered by the Registration Act, first case of partition. Second case of partition, where it has been effected by a decree of the court. अगर ये दो केस से पार्टीशन हुआ है, the daughter cannot reopen. इसके बाद अगर इसको छोड़ के अगर there has been oral partition, that will not fall under subsection 5. The doctor can reopen it because that is
Means
not a
after
party.
20th of December.
Yes,
After 20th of December.
Yes, that is the cutoff date. That is read into it. That is the cutoff date.
मैम द कट ऑफ डेट जिसके बारे में आप बार बार बोल रहे हो, कट ऑफ डेट एक्चुअली इस केस से पहले कट ऑफ डेट का कॉन्सेप्ट था. इस केस से पहले उसमें ये बोला गया था कि अगर कट ऑफ डेट है, उस डेट के बाद अगर आपके फादर नहीं थे या आप थे, तो उस चीज में फिर डॉटर्स को राइट नहीं मिलेगा. अब बात जो आप जिस केस को साइटेड कर रहे हो, जो एप्लीकेंट ने अपने आर्ग्यूमेंट में कंसिडर किया है, तो क्या उस केस में उस पर्टिकुलर केस को क्यों साइट किया गया? मतलब वो क्या चीज साबित करना चाहते थे?
उसको साइट कर इसलिए किया गया है, एक चीज को क्लैरिफाई करने के लिए कि अगर कोई पार्टीशन हो गया है, ठीक है, देखो डॉटर्स को राइट जो तुम बोल रहे हो ना, वो ये जो कट ऑफ डेट की बात करें वो एप्लीकेबल है विद रेस्पेक्ट टू द लिविंग डॉटर ऑफ द लिविंग कोपर्सन. तुम उसके रिलेटेड बोल रहे हो, मैं कुछ दूसरा बोल रही हूँ. मैं बोल रही हूँ कि अगर कोई पार्टीशन हो चुका है, ठीक है, पार्टीशन में तुमको और किसी और तुम्हारे भाई को प्रॉपर्टी मिल गया, डिवाइड होके तुम लोग अपना एंजॉय करो, तब वो डॉटर राकेश शी डिड नॉट, देन वो अमेंडमेंट हुआ ही नहीं था. उसके बाद ये एक्ट आया, the daughter is your sister reopens the whole partition. She wants to reopen the whole partition. She cannot do it. This is what the submission is. जो तुम बोल रहे हो वो दूसरा है, वो दूसरे रिलेटेड है. इसमें बोल रहा है कि अगर कोई पार्टीशन हो गया और अनुज और अर्पित अपना अपना शेयर ले लिया, शाश्वता आई 2005 के बाद, वो बोली कि गिव मी माय शेयर, बट मैम the partition is already taken by midst and bounds. The partition has been effected either by a deed of partition or by the decree of the court. You cannot reopen it. That is what the submission is, under submission given by the appellant through the case. Are you clear? समझ में आया?
मैम क्या इस केस में ऑलरेडी जो पार्टीशन था वो डीड और डिक्री के थ्रू हो चुका था?
नहीं हुआ था, नहीं हुआ था. इसलिए तो बार बार नोशनल पार्टीशन के बारे में बोल रहे हैं. नहीं हुआ था, वो प्रिलिमिनरी डिक्री हुआ था. तो यहाँ पे जब हम अभी रेशियो में जाएंगे, वहां पे कोर्ट क्लैरिफाई कर रहा है कि तुम प्रिलिमिनरी डिक्री को डिक्री नहीं बोल सकते, बिकॉज अनलेस एंड अनटिल इट इज फाइनली बाय मिड्स एंड बाउंड्स. इसीलिए यहाँ पे ये यूज हुआ है. मिड्स एंड बाउंड्स फिजिकल पार्टीशन नहीं हुआ है, तुम उसको फाइनल डिक्री नहीं बोल सकते हो. क्योंकि सीपीसी में आई एम नॉट दैट कॉन्फिडेंट इन सीपीसी, बट आई डू नो दिस दैट इवन आफ्टर प्रिलिमिनरी डिक्री, इफ देयर इज अ चेंज ऑफ सिचुएशन, द कोर्ट कैन मॉडरेट अ प्रिलिमिनरी डिक्री. ठीक है? So preliminary decree is not a final decree. So preliminary decree is not a final decree. You cannot say that preliminary decree has a finality. So even after preliminary decree, there can be change of situations because of which the very preliminary decree can have a different result. So because of that, preliminary decree will not fall under the decree which has been provided under ये जो underline किया है, देखो इसमें ये जो decree term है, इसमें preliminary decree नहीं include. इसमें सिर्फ फाइनल डिक्री होगा जहां पे कंक्लूसिवली एस्टैब्लिश हुआ है ये प्रॉपर्टी का ए पार्ट अनुज को मिलेगा, बी पार्ट अर्पित को मिलेगा, सी पार्ट मुझे मिलेगा, डी पार्ट शाश्वता को मिलेगा. दैट इज पार्टीशन बाय मिड्स एंड बाउंड्स. अनलेस दैट थिंग हैपेंस, यू कैन नॉट से दैट इट इज अ फाइनल डिक्री व्हिच विल फॉल अंडर दिस पार्ट, दिस डेफिनेशन. आर यू क्लियर नाउ?
Yeah, ma'am, this thing is clear. Ma'am, here the word is used ki the definition of corpus and in this case. तो क्या इस केस में कोपस एनर के टर्म्स को किसी नए तरीके से डिफाइन किया गया था?
नहीं, बिल्कुल नहीं. बस यही इंक्लूड हुआ था कि अब उसको रीडिफाइन, नॉट रीडिफाइन ऑल्सो, उसको क्लैरिफाई किया गया था कि कोपर्शनरी राइट हमेशा बाय बर्थ होता है. अगर तुम किसी को बाय बर्थ कोई राइट दे रहे हो, तो तुम ये नहीं बोल सकते कि कट ऑफ डेट है, कट ऑफ डेट के बाद देंगे, कट ऑफ डेट के पहले नहीं देंगे. ये तुम यू कैन नॉट आर्बिट्ररीली इंटरप्रेट दिस लाइक, राइट?
अपीलेंट्स के साइड से सेक्शन 6 का जो डेफिनेशन है को-पार्टनर्स का, वो लोग कंटिन्यूअसली लिटरल रूल पे ही स्टिक्ट थे थ्रू आउट द केस, कि लाइक बाय बर्थ. दैट्स यू वांट टू से मैम?
करेक्ट कि हाँ यू कैन नॉट रीड वर्ड्स इनटू सेक्शन 6.
तो मैम बाय बर्थ में मतलब इससे कोई फर्क नहीं पड़ता वो मैरिड है या अनमैरिड है, राइट? हाँ ठीक है, ठीक.
अभी बस
ये वाला जो इंटरप्रिटेशन है कि वो मैरिड है या अनमैरिड है, सॉरी मैम, ये वाला जो इंटरप्रिटेशन है कि वो डॉटर जो है वो मैरिड है या अनमैरिड है, वो तो इस केस में डिसाइड किया जाना था, बिकॉज ये सब इशू था. बट ये सब इशू था, लेकिन जब हम किसी केस
हुआ है, इसमें हुआ है. मैं रेशियो में जब, क्योंकि अभी तक हम आर्ग्यूमेंट्स में चल रहे हैं, अभी हम रेशियो में आएंगे. रेशियो में हम
Okay,
देखेंगे जज क्या what the esteemed judge. There are 3 judges: Justice Arun Mishra, Justice M.R. Shah. There's one more judge, Ahmad Shah, I guess. 3 judges in this. Is the
okay,
one who
ma'am.
was primarily given the decision.
Abdul Nazir.
Abdul Nazir, yes. There are 3 judges in this case. Okay, ratio of the case. Now, this particular paragraph, you will find it in every article. A son is a son till he gets his wife. A daughter is a daughter throughout her life, right? This was the heading or headline after this judgment was declared. Everywhere you would have found this particular line. So this was taken from the case of Shabita Samvedi versus Union of India. Okay, acha. I just wanted to point this out. Besides the various sources of Hindu law, custom, equity, justice, conscience have also played a pivotal role in the development of Hindu law. The reason of giving this particular ground is it says that our Hindu law is not a very restrictive law. It is because we do not have a source, we do not have a scripture, right? Like the Christian, the Judaism or the Islam, we do not have a scripture. So our law is very, very flexible. So as the society develops, whenever the Hindu law is silent to something, the judicial decisions help us. The judicial decision means that along with the constitution, they help us in determining the interpretation of various terms. So you can include the term daughter within the term of co-passion. That is the reason why this paragraph was discussed. Now, the law, by excluding daughter from participating in the co-passion ownership, not only contributes to a discrimination on the ground of gender, but also has led to operational negation of a fundamental right. A very, very basic argument which is put forward, or the very basic thing which is put forward, especially where the rights are not given equitably to a daughter. That it challenges her fundamental rights of Article 14. Again, this was a very sentimental paragraph quoted by the court in the judgment, that a daughter means a daughter throughout her life. I don't know whether it has any legal validity, but still, please, you can keep this in mind because it might come as a question as a paragraph. Acha. Partition only defines the share of a property the female is entitled to, but that does not mean that this will separate her from her family unless there is an animus to separate. Now, the reason why the court has provided this in the ratio is that repeatedly the respondent has tried to point out that the moment there is a partition, the co-passion ends, right? So the daughter cannot reopen a co-passion. The court clarified that a partition will not end her right or her position in the family, because partition does not determine whether a family is a joint family or a nuclear family. The moment, so it is the animus which decides it. The court has clarified that partition, if you are claiming partition, it does not mean that you want to separate from the family. Unless and until your animus is clear, your intention to separate is clear, or intention to separate from the joint family is clear. It is significant to note that under Section 6 by birth, right is given that is called an unobstructed heritage. Have you people read about apratibandhadaya and sapratibandhadaya property? Anybody has any idea?
No, ma'am. I don't have any idea.
Okay. Okay, I'll tell you. Apratibandhadaya, sapratibandhadaya. Sapratibandhadaya means obstructed heritage. Apratibandhadaya means unobstructed heritage. Any property which you have a right by birth, there is no, what do you say? There is no prohibition to it, or there is no checkpoint to it. If somebody, what do you say? If somebody is not existing, then only I can take a property, or that there is an obstruction. For example, I have a right by birth to my father's property. So that is an unobstructed heritage. But I have a right to my maternal grandfather's property. That is an obstructed heritage. Only if my maternal grandfather has no heirs, then only I can take that property. So this is an obstructed heritage. Unobstructed heritage is a very essential characteristic of Mitakshara family, Mitakshara system, Mitakshara law. Whereas obstructed heritage is a part of Dayabhaga law. So when we talk about co-partial system under Section 6, it is an unobstructed heritage because the daughter and the son, they have a right by birth. They can take the property if they have, because they have right by birth. Okay, so it is a obstructed heritage.
Ma'am,
Unobstructed heritage. Yes.
hello.
मैम एक बार
Can
दोबारा
you
रिपीट कर
please?
दीजिए
Yes, ma'am. Same doubt.
I am using the term
मैम
obstructed and
मैम
unobstructed.
मैम
हाँ,
हिंदी में कर दीजिए प्लीज प्लीज
हिंदी
यूज
ठीक है.
हिंदी
काइंड ऑफ प्रोनाउंसिएशन अगर थोड़ा खराब हो तो प्लीज पार्डन मी. अच्छा,
कोई नहीं
there are two things, there are दो कॉन्सेप्ट है, obstructed heritage, unobstructed heritage. ठीक है. obstructed heritage को हम बोलते हैं सप्रतिबंधदाय, unobstructed heritage को बोलते हैं अप्रतिबंधदाय. सप्रतिबंधदाय मीन्स obstructed, प्रतिबंध के साथ है जो. unobstructed means अप्रतिबंधदाय. there is no obstruct, कोई obstruction नहीं है वहां पे. obstruction मतलब चेक पॉइंट, लिमिटेशन, बैरियर, जो भी हो. मेरा राइट मेरे फादर की प्रॉपर्टी में बाय बर्थ है, कोई वहां पे ऑब्स्ट्रक्शन नहीं है. ठीक है. आई कैन क्लेम दैट प्रॉपर्टी और राइट टू द प्रॉपर्टी एनी टाइम आई वांट. आई कैन क्लेम दैट, मतलब कोई भी टाइम पे आई कैन क्लेम इट. कोई लिमिटेशन नहीं है मेरे लिए कि मेरे को कोई नहीं होगा तभी जाके मैं क्लेम कर सकती हूँ, नहीं है वो. तो उसमें कोई ऑब्स्ट्रक्शन नहीं है. सो दैट इज एन अनऑब्स्ट्रक्टेड हेरिटेज. वो अनऑब्स्ट्रक्टेड क्यों है? क्योंकि मेरे पास राइट बाय बर्थ है, जैसे कि कोपार्शनरी सिस्टम में होता है मिताक्षरा स्कूल ऑफ लॉ में. बट अनऑब्स्ट्रक्टेड हेरिटेज क्या है? मैं अगर मेरे मैटरनल ग्रैंडफादर मतलब नाना जी, उनकी प्रॉपर्टी में अगर मैं कोई क्लेम करूं, मुझे उस प्रॉपर्टी में शेयर तभी मिलेगा अगर मेरे नाना जी के पास कोई आयर नहीं है. देयर इज नो लीगल आयर टू टेक द प्रॉपर्टी. उनका प्रॉपर्टी लेने के लिए कोई अगर आयर नहीं है, देन आई कैन क्लेम इट एंड और आई कैन गेट इट. वहां पे एक ऑब्स्ट्रक्शन है. ऑब्स्ट्रक्शन क्या है? कि उनका एक लीगल आयर है. अगर वो लीगल आयर, हाँ,
मैं अपनी नाना की प्रॉपर्टी में अपनी मदर का शेयर नहीं ले सकता.
मदर लेगी ना, चेक से वहां पे.
अच्छा, मतलब मैं मदर
हाँ,
को
तुम ले
क्लेम कर
सकते हो,
सकता हूँ.
बट क्वेश्चन ये नहीं कि तुम ले सकते हो कि नहीं ले सकते हो. क्वेश्चन ये है कि वहां पे कोई चेक है कि नहीं, वहां पे कोई बैरियर है कि नहीं. अगर कोई बैरियर है, ठीक है, तभी जाके वो ऑब्स्ट्रक्शन है. इसलिए उसको ऑब्स्ट्रक्टेड हेरिटेज बोलते हैं. तुम ले सकते हो, क्वेश्चन ये नहीं कि तुम ले सकते हो कि नहीं ले सकते. अगर तुम्हारी मदर शी आफ्टर शी गॉड फॉरबिड passes away, then only you can get the property. There is that barrier, there is that checkpoint, there is that obstruction. ठीक है, वो ऑब्स्ट्रक्शन है.
मैम क्या ऑब्स्ट्रक्शन का मतलब ये है कि हमें किसी के कंसेंट पे या किसी के
नहीं
कि उस पर डिपेंड होना पड़ेगा?
देखो, तुम्हारा ऑब्स्ट्रक्शन या तो डेथ हो सकता है, सॉरी प्रेजेंस हो सकता है, या डिस्क्वालिफिकेशन भी हो सकता है. अगर कोई लीगल है डिस्क्वालीफाई हो गया प्रॉपर्टी लेने से, ठीक है, तो वो ऑब्स्ट्रक्शन हट गया. समझ में आया?
Yes,
तो
ma'am.
हाँ, तो ऑब्स्ट्रक्शन मतलब ये नहीं कि कोई अगर नहीं होगा, somebody is not alive anymore, नहीं. अगर वो आयर डिस्क्वालीफाई हो गया, ठीक है, तो तुम्हारा डिस्क्वालिफिकेशन का ग्राउंड है हिंदू सक्सेशन एक्ट में. अगर उसके बदौलत कोई डिस्क्वालीफाई हो गया तो तुम्हारा ऑब्स्ट्रक्शन हट गया. बट स्टिल फिर भी उसको तुम ऑब्स्ट्रक्टेड हेरिटेज बोलोगे, क्योंकि तुमको वेट करना पड़ेगा उस ऑब्स्ट्रक्शन के लिए, ऑब्स्ट्रक्शन के हटने तक के लिए. ठीक है. बट तुम्हारे फादर की प्रॉपर्टी के लिए तुम्हारे पास कोई ऑब्स्ट्रक्शन नहीं है, तुम कभी भी क्लेम कर सकते हो. The moment you are major, you can claim it, or you can claim it anytime. So that is अप्रतिबंधिताय हेरिटेज. तो यहाँ पे वाई क्यों इंपॉर्टेंट है, ये कॉन्सेप्ट क्यों यूज किया गया है कि तुम्हारा जो को-पार्शनरी राइट है, हम बार बार वही रिइटरेट कर रहे हैं कि वो राइट बाय बर्थ है, वो अनऑब्स्ट्रक्टेड हेरिटेज है. तो अगर कोई चीज अनऑब्स्ट्रक्टेड हेरिटेज है जो मैं बाय राइट क्लेम कर सकती हूँ, तो मैं उसके लिए क्यों वेट करूं, मैं उसके लिए ये कंडीशन क्यों देखूं कि वो इंसान लिविंग होना चाहिए वो कट ऑफ डेट पे, बिकॉज इट इज एन अनऑब्स्ट्रक्टेड हेरिटेज. I have a right by birth, I have no obstruction, so therefore I can claim it. That is the reason the court is giving it, that the right of a co-partner by virtue of section 6 is an unobstructed heritage. You cannot debar me, you cannot put a check in form of a cut-off date, या put a check in form of child of a living co-partner. You cannot put that check because it is an unobstructed heritage. Thus, the co-partner did not be alive on 9/9/2005, date of substitution of provision of section 6. The concept of uncodified law of unobstructed heritage has been given a concrete shape under the provision of section 6 subsection 1a and 6(1). This whole section 6 subsection 1, you'll find that unobstructed heritage has been put down very clearly, right? So here I have given you the distinction between obstructed heritage and unobstructed heritage. If you want more a detailed information on it, you can refer to Paras Diwan, Hindu law, modern Hindu law. There is 2 pages of discussion on Apratibandadaya, not 1 page also. There is a 1 paragraph discussion on Apratibandadaya, Sapratibandadaya heritage. Just 1 paragraph discussion on it, very clear, very crystal clear. Okay. Next, this is the term which I was saying. That is, the section 6, the amended section 6 is not retrospective, rather it is retroactive. Okay, we are using the wrong term called retrospective. Here, I am going to give you the difference between retrospective statute and retroactive statute. Prospective statute operates from the date of its enactment. जब से enact हुआ, तब से वो right provide करेगा. Retrospective statute is something which operates backward. ठीक है? And it takes away or impairs vested rights which were acquired under the existing law. तो पहले कोई अगर तुमको राइट मिल रहा था, अगर किसी लॉ का रेट्रोस्पेक्टिव राइट है, एप्लीकेशन है, तो वो राइट वो बैकडेट से भी ले लेगा, या बैकडेट से भी वो कोई राइट तुम्हें कन्फर कर सकता है. देयर कैन बी 2 सिचुएशंस. But a retroactive statute is the one which does not operate retrospectively. It operates in future. इसका application is prospective, but its operation is based upon the character or status which arose earlier. We are going to use this definition in the current ratio, or the court has used this one in this particular definition or concept to clarify the application or the applicability of section 6. अच्छा
नहीं समझ आया retroactive.
हाँ मैं नहीं आएगा, it's okay. मैं अभी इसके साथ समझाऊंगी तो समझ में आएगा. सुनो, again I'm reading the definition, then I'll come back. Retro, हाँ.
अभी रेट्रोएक्टिव का अगर मीनिंग गूगल करते हैं तो उसमें दिखाता है कि रेट्रोएक्टिव का मतलब ये है कि आप किसी भी चीज को एक डेट के बाद से फोर्स कर रहे हैं. सपोज रेट्रोस्पेक्टिव में दिखाता है कि फ्रॉम द बिगिनिंग, जब से शुरू हुआ है तब से, और रेट्रोएक्टिव में वो दिखाता है कि फ्रॉम अ डेट you follow a particular date on which you force that particular law. So is it right? Matlab it is correct or?
It is correct, but partially. Retroactive means you are applying the law prospectively. एक future date से apply कर रहे हो, but वो application एक back date या एक situation पे हो रहा है जो कि previous वो past में हो चुका है. ठीक है? तुम उसको apply कर रहे हो future से. मतलब आज अगर लॉ पास हुआ तो वो लॉ को तुम कल से अप्लाई कर रहे हो, बट जो तुम अप्लाई लॉ कर रहे हो एप्लीकेशन का बेसिस इज अ सिचुएशन व्हिच हैज हैपेंड इन द पास्ट. ठीक है, जो कि प्रोस्पेक्टिव में नहीं होता है. प्रोस्पेक्टिव गिव्स नो कंसीडरेशन टू एनीथिंग व्हिच हैज हैपेंड इन द पास्ट. बस ये चीज याद रखो. मैं तुमको इसको सेक्शन 6 के साथ एडजस्ट करके पढ़ाऊंगी अभी. अच्छा लिसन, अ retroactive statute is the one that does not operate retrospectively. It operates in future. However, its operation is based upon the character status that has arose earlier. Characteristic or event which happened in the past or requisites which had been drawn from antecedent events. Antecedent मतलब past में जो हुआ है. How am I going to apply, or how has the court applied this in the current section 6? 2005 में आया law कि daughters are going to be co-partial. ठीक है, daughters are going to be co-partial. 2005 के बाद से वो अप्लाई हुआ. So the application of section 6 is in future. ठीक है, क्योंकि वो उसको जो शेयर मिलेगा वो पहले मिला नहीं है. That is, ठीक है, it will apply in the future, but the applicability is on a fact which has happened in the past. The situation is that she was born and by birth she has got a right of co-partiality. ठीक है, ये जो retroactivity has been put in the section only. I'll take you to the section. ये जो section देखो, by birth she becomes a co-partial. By birth she becomes a co-partial. So this is the antecedent event. ये जो situation है, वो birth ली 2005 से पहले. ठीक है, section 6 बोल रहा है कि by birth वो co-partial बनी. ठीक है, ये एक पास्ट इवेंट है जिसके बेसिस पे उसको 2005 के बाद से राइट मिल रहा है प्रॉपर्टी में. तो ये रेट्रोस्पेक्टिव एप्लीकेशन नहीं है, ये रेट्रोएक्टिव एप्लीकेशन है. लॉ अप्लाई हो रहा है उसको प्रॉपर्टी मिलेगा 2005 के बाद से, प्रोस्पेक्टिव एप्लीकेशन, बट एक सिचुएशन के ऊपर जो कि 2005 से पहले हुआ है, दैट इज हर बीइंग बोर्न इन द फैमिली एंड दैट राइट ऑफ अ को-पार्टनर. इज इट क्लियर नाउ?
मैम इसका मतलब ये हुआ कि ऐसे बोला जाता है कि आपका रेट्रोस्पेक्टिव इफेक्ट नहीं होता है, आपका ऐसे प्रोस्पेक्टिव इफेक्ट होता है, ठीक है. तो बेसिकली रेट्रोएक्टिव उस टर्म को बोला गया है क्योंकि यहाँ पे तो बाय बर्थ टर्म यूज करके यहाँ पे तो डेट को भी नहीं देखा जा रहा है ना. अब वो बर्थ तो यहाँ पे ना प्रोस्पेक्टिव है ना रेट्रोस्पेक्टिव है, तो इसको हम इसलिए रेट्रोएक्टिव टर्म दे रहे हैं, राइट?
हाँ, करेक्ट.
ठीक है.
क्योंकि हम कुछ पास्ट से कुछ सिचुएशन लेकर जो कि फाउंडेशन सिचुएशन है उसको लेकर हम फ्यूचर एप्लीकेबल फ्यूचर में लेकर अप्लाई कर रहे हैं. प्रोस्पेक्टिव फंक्शनिंग ऑफ अ लॉ बेस्ड ऑन एन एंटीसीडेंट इवेंट. एंटीसीडेंट इवेंट क्या है? दैट शी वाज बोर्न एंड शी वाज बाय बर्थ अ को-पार्टनर.
मैम लाइक बर्थ 1990 में हो चुका है, बट अमेंडमेंट एक्ट आया 2005 में, एंड तब से एक्ट कंटेन करता है कि बाय बर्थ मींस बाय 1990, दैट्स रेट्रोएक्टिव
फ्रॉम 1990. एग्जैक्टली, यस, करेक्ट.
ओके मैम, थैंक यू मैम.
करेक्ट. चलो, गुड. नाउ विल कम टू, दिस इज क्लियर. रेट्रोएक्टिव का मतलब सबको पता चल गया तीनों का? अगर
Yes,
आएगा
ma'am.
Yes, ma'am.
ग्रेट, थैंक यू. ठीक है. सो ये एक चीज है जो कोर्ट यहाँ पे एस्टेब्लिश किया. इट्स अ वेरी वेरी वेग कॉन्सेप्ट क्योंकि ये बार बार रिपीट हो रहा है. ये तीनों के चारों काउंसिल ने इसको रिपीट किया, कोर्ट ने भी उसको रिपीट किया. कोर्ट द esteemed court also mentioned that if there is a past transaction, it gets saved from the application of amended section 6. So the daughter would step into the co-partnership as that of a son by taking birth before or after the act, doesn't matter. However, daughter born before can claim these rights only with the effect from the date of the amendment. This is your retroactive law. This is a retroactive application of the law. If she is born before the cutoff date or before the commencement of the act, she can take the right. She can claim the right only after the date of the amendment. She cannot claim before it. The moment the law comes into existence, her rights gets crystallized. Retroactivity of the law. So iska jo application, I have given a clarification here. Okay? So now, when the testator dies before 20 December 2004, testamentary disposition of undivided interest would remain unaffected. So if the testator, who is a testator? Testator is a person who has made a will and died. Okay? If the person died and has not made a will, he would say he has died intestate. Okay? So if a particular person, he has made a will, then he has died, and the will has been made before 20 December 2004. So in such a case, uska jo will hai, that will be final. That will have no effect from section 6. Section 6 का उस पे कोई इफेक्ट नहीं होगा अगर वो विल इस डेट के पहले बना है. अगर उस विल में वो किसी को प्रॉपर्टी नहीं दिया है, किसी को दिया है, डॉटर को नहीं दिया है, सन को दिया है, section 6 cannot challenge it because that is saved from it. However, if suppose any co-partner who executes his last will, although before 20th December 2004, but dies after the same date, then in that case, testamentary disposition of his interests shall remain subject to substituted provision. If the testator has made a will before 20th December 2004, but dies after the cutoff date, his will can be challenged on the basis of section 6. So यहाँ पे what is the taking away from this part of the ratio is that it is the death of the co-partner or the ancestor which decides. Okay, which decides at least in such cases whether the law will be applicable or not applicable. Okay, final two points. First of all, if any appeal or if any proceeding is pending during the, so a koi appeal has been is there since 2003 and it is even pending on the date of the amendment. So it says that even if the proceeding is pending, the law will still be applicable. So the amended provision will have an applicability on pending proceedings. Now next, last one, ये मैं already बोल चुकी हूँ कि even in case of a preliminary decree will not be a final decree. So preliminary decree के बाद if the amendment act has been passed, still the law will be applicable to such a situation. I've also provided you the judgment, the precedent from where the court has established this particular ratio. Finally, the statutory fiction of partition. Now, the court has tried to explain one more thing, that the moment there is a partition, अगर कोई partition हुआ, partition का मतलब ये नहीं है कि तुम चाह रहे हो कि तुम family से separate हो. Partition is only for the purpose of ascertaining the share of the deceased co-partner. Why has this point been discussed? In the current case, right? In the current case, there has been a kind of a partition as an oral partition, right? Where even if it was not strictly falling within the term of partition, but it was backed by certain evidences or witnesses. So there has been a ground or which has been raised which says that partition ho gaya hai, separation ho gaya hai, everything has happened. The daughter cannot reopen it. Partition, at least a partition or a notional partition, is just a fiction to ascertain the share of the property. It does not mean that you are trying to separate from the family. Okay? So you cannot say that partition means breaking of the joint family system or breaking of the joint family. This is not anyway much relevant to the judgment, but since it has been discussed as a part of a ratio, I felt it apt to discuss it. Now, I know this is a bit scattered, so what I have done, I have given you overview of everything which I have discussed now. So I think this pointers here will help you to summarize the whole decision which has been put forward by the court. First of all, the provision contained in the substituted section of Section 6 of the Hindu Succession Act 1956, it confers the co-partner status on the daughter. May be born before, may be born after the Amendment Act. In the same manner that of a son, the same rights and liabilities. The court has disagreed on the concept of living co-partner and mentioned that the amended term in Section 6 of the Act is daughter of the co-partner, not daughter of a living co-partner. You read the term living into the provision which is not present in it already. The rights can be claimed by the daughter born earlier with effect from 9/9/2005. Provided it is not a past transaction, that it has not been crystallized. Since the right in co-partnership is by birth, it is not necessary that the father co-partner should be living on 9/9/2005. Daughter's right arises not to the death of the father, but by the factum of her birth. So right by co-partner is a right given by birth, and not because the moment the father dies that the right will come into action. No, the daughter has it by birth. The benefits conferred by the provisions are based on antecedent event, and the Mitakshara co-partner law should be deemed to include the rights. So we discussed this particular part when we were discussing the retroactivity in the unobstructed heritage part. The statutory fiction created of partition, the notional partition created by proviso to Section 6 of the Hindu Succession Act is not actual partition or disruption of co-partnership. If there arises a situation, please be attentive to this part. If there arises a situation wherein the father died in 1997 and the daughter married in 2001, right? And there are two sons who believe that there exists a notional or an oral partition when their father had died without any documentary evidence supporting the claim of partition, then there exists no explicit or settled partition of the property. So this means that in case there is even a notional partition is not a partition, because if you remember the last explanation of Section 6, which says that partition by decree or a partition by registered deed is protected from the amended Section 2005 amended section. This particular paragraph here given by the judgment, is by the court, esteemed court, says that a notional partition is not a partition within that last exception. That partition only includes a partition by a decree or a registered document. That's it. Finally, notwithstanding that a preliminary decree has been passed, the daughters are given share in the co-partnership equal to that of the son in pending proceeding for final decree or an appeal. So it establishes that a preliminary decree is not going to abandon the daughter of any rights. A preliminary decree is not a final right. And finally, this was what we were discussing. There was no distinction in rights of a married female and an unmarried female. So this distinction, this very point of distinction which was used in Prakash versus Fulvati, that a married female should be excluded from taking any right to the property. You cannot read words like married female or unmarried female into section 6. It is violating the provision of interpretation. You cannot read that. So by creating a distinction between married female and unmarried female, you are actually creating an arbitrary distinction which does not have an intelligible differential. You need to have an intelligible differential. Just because that the son or the great grandson or the great grandchildren of the married female can come and claim share in her mother's property, you cannot take this as a ground to to create such exclusion. So this distinction was, it was erased out from the very argument which is put forward. If in a situation, if the living co-partner dies after 9/9/2005, the inheritance would not be acha. This is actually an interpretation of section 6. Now, section 6 creates two categories of devolution of property. एक devolution है तुम्हारा जो 9/9/2005 के बाद आता है, ठीक है? एक प्रॉपर्टी, एक डिवोल्यूशन है जो तुम्हारा उसके पहले आता है. अगर सेक्शन 6 आने के बाद से अगर कोई प्रॉपर्टी डिवाइड होगा कि कोई बर्थ ले रहा है, कोई डेथ हो रहा है, तो उसमें ये चीज अप्लाई होगा. डॉटर्स विल गेट इक्वल शेयर. इट द डिवोल्यूशन विल बी अकॉर्डिंग टू सेक्शन 6. अगर उसके पहले कोई डिवोल्यूशन हो रहा है, द डिवोल्यूशन विल बी अकॉर्डिंग टू द मिताक्षा स्कूल ऑफ लॉ, जो तुम्हारा नॉर्मली होता है राइट बाय सर्वाइवरशिप, जो मैंने एक्सप्लेन किया है पूरा बिगनिंग में. ठीक है, हर को-पार्टनर को अपना शेयर मिलेगा, एक ही ब्रांच में जाएगा, नेक्स्ट ब्रांच में वो नहीं जाएगा. ठीक है, दैट इज पार्टीशन पर्स टाइप्स. So this is the final, so this is the overview of the case, and we are done with the case. Any doubt anywhere?
Ma'am, this last paragraph number 9.
अच्छा, listen. जो तुम्हारा section 6 है, ठीक है, amended section 6. Amended section 6 says that now before the Hindu Succession Act, जो पहले Hindu Succession Act आया, उससे पहले